Ladies and gentlemen, earlier this week, we finally got a ruling on a case with the potential to have significant impact on high school sports in Wisconsin. But did it? In the case of Hayden Halter v. Wisconsin Interscholastic Athletic Association, the Wisconsin State Supreme Court ruled 5-2 in favor of the WIAA. Tuesday's ruling overturned the ruling of a lower appellate court in 2024 that had reinstated Halter's 2019 WIAA Division I state wrestling title at 120 pounds. How did we get here? Well, this case dates back to February 2nd of 2019. Then sophomore wrestler Hayden Halter was assessed two unsportsmanlike conduct penalties that would have banned him from competing in the WIAA regional tournament, thus ending his season. The Halter family successfully filed for an injunction before the regional tournament, allowing Halter to compete and ultimately go on to win the WIAA D1 state title. We will have links to our previous reporting on this winding saga below, but I wanted to explore this ruling further to understand the questions it did and did not answer. Joining me again this morning, as he did in October upon the start of oral arguments, is 35-year Marquette law professor Matt Mitten, who specializes in sports law. Good morning, Matt. Once I get you on here, thank you so much for joining us.
Good morning, Zach.
Great to have you back. Professor, I want to start with what Tuesday's ruling did answer, which, as we know, was a 5-2 ruling in favor of the WIAA, ultimately defending the organization's application of its rules and initially suspending Halter. What did you make of the majority opinion authored by Justice Brian Hagedorn on the reasoning for that ruling?
Well, kind of the bottom line is, after all is said and done, there's a lot more said than done. So the ultimate result is that Mr. Halter is going to lose his state wrestling championship, which is unfortunate for him. But the majority seem to go to great pains not to really answer a couple of key legal issues, one of which would be, as the dissenting justices point out, whether the WIAA is a state actor or not. And if it is, then it would have to comply with the requirements of the federal Constitution. The majority opinion said not necessary to address that. The majority also seemed very reluctant to address the issue of, well, what would be the appropriate scope of judicial review by Wisconsin courts of, for example, athlete eligibility decisions, disciplinary actions like the case here that were made by the WIAA. So that's why I say, as you pointed out, 6 years of litigation and some very important issues are not, finally resolved by the Wisconsin Supreme Court.
Mm-hmm. And, the petition for this case, like you kind of just pointed out, was ultimately accepted by the state Supreme Court on the basis of 5 questions. The most consequential of which was, is the WIAA a state actor? Professor, can you refresh our viewers' memories on the legal consequences of that question for an organization like the WIAA that views itself as private?
Well, it's very significant. So a number of courts have addressed this issue. It all starts with a United States Supreme Court decision. It's about 20 years old now. And the U.S. Supreme Court has said, depending upon how a state high school athletic association is structured, it may be a state actor. That is a case-by-case, fact-specific situation. And there it involved the Tennessee governing body for high school sports. And there the court said, well, there is enough involvement, a majority of the schools in Tennessee, let's step back. I think it was like some 83% of the member schools of the Tennessee high school athletic governing body were public. So they had de facto control of it. And it was largely, the principals, superintendents, and others, athletic directors. And the court said because there was effectively state high school institution control, the rules, decisions of that particular high school athletic association were subject to the requirements of the federal Constitution. For example, you have to provide due process. equal protection, respect First Amendment rights, free speech, religion, for example, which are very important rights. And, a number of, I think, for example, Michigan has been held to be a state actor. There's a couple other states. West Virginia might have been one where their Supreme Court's applying the U.S. Supreme Court's Brentwood decision said, no, they're not. In this case, the 5-judge majority just did not express any opinion on that issue. They just said not necessary to resolve it, this particular case. The 2 dissenting justices say, well, why did we even grant cert in this case if we didn't address this important issue? It's interesting that the 2 concurring justices, it looks like they would have been willing to address this issue and simply say the WIAA is a voluntary private association. It's not created by the state of Wisconsin. Its rules are determined by contract, meaning agreement among its member schools. And it's not a state actor that has to comply with the requirements of the federal Constitution.
Yeah, touched on a couple different threads of this that are kind of fascinating to go on. I mean, let's start with just the very fact of a significant question that obviously transcended this state individual wrestling title at 120 pounds from 6 years ago. Yet one dismissed in the majority ruling as far as the state actor question, with Justice Hagedorn writing, the parties spill much ink debating this question, seemingly in response to the Court of Appeals' view that this was a threshold question to cert, as you discussed recently. And I guess were you as surprised as I was to see the court ultimately not rule on the state actor question? It seemed like the entire reason for taking this case.
Well, and my understanding is the Wisconsin Court of Appeals found that the WIA was a state actor. And as I recall from reading the briefs, the WIA said, well, that wasn't really there weren't any federal constitutional law claims raised by the Halters at the circuit court level. And the WIA did not want that intermediate appellate court decision to be precedent because it really wasn't effectively briefed and addressed. Apparently it was in the briefings to the Wisconsin Supreme Court. And in fact, as the dissent points out, the WIAA did ask the Wisconsin Supreme Court to address that issue. And the majority declined to do so. So then it's back to, well, why did they accept cert in the case? I guess the bottom line is by reverse, the Wisconsin Supreme Court did reverse the intermediate appellate court's decision. So that has no precedential value. So the issue of whether the WIAA is a state actor remains unresolved. And that's really the point of the dissent. The dissent takes the view of that, well, if we accepted cert, we should have addressed that issue. If we didn't, then the case should have been dismissed as improvidently granted. But then, ironically, that would mean the appellate court's decision is upheld, meaning WIA is a state actor and Mr. Halter keeps his state wrestling championship. And the majority clearly didn't want to do that. They did not want to address the state action issue. But they did not think that the appellate court had a valid basis for reversing the determination of the state trial court, which held that the WIA's interpretation of its rule was reasonable. Because if we go back to the facts, Mr. Halter was suspended for an act of unsportsmanlike conduct during this conference championships. And then, of course, the regionals was the opening round of the state 3-stage state tournament. And what he sought to do is sign up for a junior varsity tournament, even though he'd never wrestled junior varsity, sit that out, and wanted that to satisfy his one event suspension for unsportsmanlike conduct, which is what the WIAA rules provided. So I think the Wisconsin Supreme Court got it correct that this was a reasonable interpretation of the WIAA's rules. They said, hey, if you're wrestling at the varsity level, you have to sit out the next varsity wrestling event, which would have been the regionals, which effectively, rendered Mr. Halter ineligible to defend his state championship. He's a sophomore. He'd won it as a freshman, but yet the majority did not want to address the very important underlying legal issue in the case.
Interesting. So as I'm gathering what you're saying, I mean, it sounds like despite not explicitly addressing the state actor question themselves, by not dismissing the case, there is kind of, it relies on the precedent of one of the appellate decisions that basically defines it as not a state actor.
No, I think, well, what they did is the Wisconsin Supreme Court basically said by reversing the appellate court's decision, I would read the case as basically invalidating the Wisconsin Court of Appeals determination that the WIAA is a state actor. It's interesting. They reverse, very clear. They reverse the Court of Appeals decision, but without really saying that, well, its determination that the WIAA is a state actor was wrong. It does, because the majority decides we're not going to address that issue. They just basically said the appellate court's determination that which reversed the trial court. The trial court held that it was reasonable. And I agree with that. I agree that it was the way the WIAA interpreted rules, it was reasonable. And that was really the main claim that was raised by the Halters. But the appellate court went a little bit further because they found that the WIAA was a state actor. And, usually the basis for granting cert, as the majority points out, let me get the exact language here. It says the Wisconsin Supreme Court is a law-developing court. It doesn't just, routinely review decisions of lower courts. But yet the majority, the 5-judge majority, they said, we are not going to address the issue of whether the WIAA is a state actor. So we don't have a definitive ruling to that issue.
Interesting. And yeah, I mean, you kind of touched on another quote that stuck out to me in the dissent. Chief Justice Ziegler, put in her dissent rather plainly a citation to another case where she says, we are not an error-correcting court. We are a law-developing court. And I guess with that said, and, this case kind of reviewed from the 1,000-foot view, assuming that this is the end. We'll get into that in a moment here. But, if this is the end, what law, development has taken place as a result, in your estimation, of this case?
Well, if we look at what are the governing laws that would apply to a state high school athletic association governing body like the WIAA, clearly, contract law, because you've got, the opinion notes that all of the public high schools in Wisconsin are voluntary members of the association. So they have both a voice and a vote in making the rules, and all of the schools, and there's also private schools that are members. So all the schools have a voice and vote making the rules. They all agree to comply with those rules, and the governing, I think it's the Board of Control, that's the highest entity, and they agree that its decisions are going to be final and binding. So contract law applies. There's also a doctrine known as the law of private associations, which says entities that are private, meaning they're not governmental bodies or state actors for purposes of federal constitutional law, they not only have to comply with their own rules, but they have to, do a couple other things, because they would have, here it's a type of monolithic governing authority. Since all the public and private high schools in the state of Wisconsin are members of this body, there's not any alternative governing body out there. Courts, in applying the law of private associations, say, well, you've got to provide appropriate notice to everyone, the schools and athletes, of what conduct is prohibited or required by the rules. So those, need to be clear. And there's usually, it means that there's got to be some sort of process for either a school or an athlete who's adversely affected by a rule or its interpretation to be heard within the association, some sort of, internal appeal. And the decision, final decision, needs to be reasonable, meaning not irrational or arbitrary. And here that was satisfied. I mean, the majority, it seems like everyone agrees that the WIAA's rule and its interpretation and application in this case was reasonable. So that would certainly require with that requirement. And then the other thing is typically that even a private association must comply with other applicable state and federal laws. And one of them would be, if we go back to the case, it was Brentwood Academy, even though the Tennessee high school governing body was a private entity, it was found to be a state actor for purposes of federal constitutional law, because it was effectively controlled or could be controlled by the public high school members of it. That's the key issue that is not resolved by the Wisconsin Supreme Court. So just to kind of summarize, it's pretty clear that the WIAA must comply with the rules that it has enacted. And two, it's got to apply those rules in a reasonable manner, which here the Wisconsin Supreme Court said that it did. But beyond that, there isn't a definitive ruling. Pretty clearly there was not a determination of whether the WIAA is a state actor, and if so, it would have to comply with federal constitutional law. And again, as we talked about, that would be providing due process, equal protection, complying with First Amendment rights, and anything else basically in the Bill of Rights.
So with that said, I mean, will it take another case working its way through the appellate courts to get to the state Supreme Court to finally get them to revisit this question then, essentially?
Yes, I believe it would. It looks, it's a little bit, the majority says, well, because the Halters did not raise a federal constitutional law claim, at least in their initial, state court, trial court proceeding, the majority seems to be saying, we don't need to raise that. And the dissent's response is, well, why do we accept cert? Because we're not an error correcting court. That's an important legal issue. So yes, it does appear that, at least in the eyes of a majority of the Wisconsin Supreme Court, a constitutional law claim, federal constitutional law claim, is going to need to be asserted at the state trial court level. And that's, going to depend, the trial court's going to have to, based on the parties' arguments, determine whether it thinks that the WIAA is a state actor who has to comply with the requirements of the federal constitution. Whatever that decision is would have to be appealed to a Wisconsin intermediate appellate court. And then the party who would lose, depending upon which way it came out, then would have to petition the Wisconsin Supreme Court for review, determination of whether applying the U.S. Supreme Court's Brentwood Academy decision, does the WIAA meet the requirements for finding that it is a state actor subject to the requirements of the federal Constitution, or the two concurring judges, they say, hey, we're satisfied that the WIA is only a private association. It is not a state actor, and therefore it does not have to comply with the requirements of the federal Constitution. So it looks like there's at least two current justices, based on their review of the parties' briefs, and I'm not sure what arguments were actually made during the Supreme Court hearing. They seem to be of the view that the WIA is a private organization, and based on the facts, they are not a state actor who has to comply with the requirements of federal constitutional law.
In speaking with both parties on Tuesday, I got the sense that this will likely be the end of a 6-year legal battle over this state wrestling title. The case can be petitioned to the U.S. Supreme Court, but the sense I got was it may not be worth continuing the fight for the Halter party in particular. If they were to decide to petition the U.S. Supreme Court, what, in your view, is the time frame and likelihood it would be accepted?
Well, I'm not entirely sure of the time frame. The parties, the clock that starts, I would say within a couple months on that. But I think it is unlikely that if there were a petition for review submitted to the U.S. Supreme Court, that it would be accepted, because the Wisconsin Supreme Court did not address the issue of whether the WIAA is a state actor. I don't think that's something the U.S. Supreme Court would accept cert. That if the Wisconsin Supreme Court had addressed the issue one way or the other, whether the WIAA is a state actor, then it would be very interesting to see if there has to be at least 4 U.S. Supreme Court justices who would vote to hear the case. I know Justice Thomas has been very critical of the Brentwood Academy decision that state high school athletic associations can be, depending upon the facts, state actors that must comply with federal constitutional law. Given that there is a supermajority of the current U.S. Supreme Court who have very conservative views, it would be interesting to see whether or not there'd be 4 justices who say, yeah, let's revisit the Brentwood Academy decision and perhaps overturn it, because the current court has certainly not been reluctant to overturn even long-standing judicial precedents that it disagrees with. But I don't think there is a basis that's going to convince 4 U.S. Supreme Court justices to even consider the issue, because the Wisconsin Supreme Court did not address the issue of whether the WIAA is a state actor in this particular case. But I do agree that the issue, the basic issue of does Mr. Halter get to retain his state championship, I think that has been finally resolved.
Well, 6 years later, we finally have an answer on that. Professor Mitten, thank you so much for joining us. Any other thoughts just on this case overall? It seems like we hit the major beats, but anything else that just strikes you about just what this 6-year saga has kind of been? Feel free to put a bow on it any way you feel like.
Well, I think that this case did provide the opportunity for the Wisconsin Supreme Court to address a very important issue. And that is, does the WIAA have to comply with federal constitutional law requirements or not? And, unfortunately, that is going to have to wait for another day. So there is that continuing legal uncertainty, but I guess as a matter of procedural law, since there was never a federal constitutional law claim raised by the Halters in the initial, filings, I can see why the majority would say, hey, we don't need to address that. So I think it's likely that given the right set of facts, counsel for, an athlete or member school is going to raise that. I mean, that's the lesson to be learned from this case is that whether it's an athlete or a school, if they want to assert a federal constitutional law claim against the WIAA, they need to do it at the trial court level and get a ruling on that. And then that can be appealed to, Wisconsin Intermediate Appellate Court. And then it would be ripe for the Wisconsin Supreme Court to address the issue, but it would be a discretionary certiorari. I think in this case, although, again, it was here, the appellate court said WIA is a state actor, but the majority of the Wisconsin Supreme Court decided to reverse the Court of Appeals on a much more narrower grounds. They just simply said, hey, this was a reasonable decision by the WIAA, and it is not necessary for us in actually resolving the case that way to decide to whether or not WIAA is a state actor.
So ultimately some clarity, but maybe, something a little bit left on the table for both sides here. But Professor Mitten, thank you so much for joining us. If you've watched this far, thank you for joining us in this discussion about the potential conclusion of a 6-year legal battle over a WIAA state individual wrestling title. Please consider subscribing to support our efforts to deliver news impacting your community at jsonline.com. And